Hello, everyone, and thank you for joining us. I am Katie Horner, the LLM Fellow for the Environmental Law Program at the Elisabeth Haub School of Law. Before we begin today's event, I'd like to provide you all with a few announcements. Today's event will include a brief moderated Q&A session with our presenter, Professor Erika George. We will be using a web application called Slido to coordinate the Q&A. To participate in the Q&A session, simply click on the link provided in the chat. Type and submit your question into the submission box on the Slido page. To share your thoughts about today's event and stay connected with us for future programming, tag and follow us on Twitter. To learn more about past Garrison lectures, please visit the link provided in the chat. Lastly, I'd like to remind you all that today's event is being recorded, and by participating, you are consenting to being recorded. Thank you all again for joining. We will begin the event momentarily. At this time, I would like to invite Professor Jason Zarneski, the Associate Dean and Executive Director of the Environmental Law Program, and the Kurland Distinguished Professor of Environmental Law to open the event. Professor Zarneski.
Good evening, everyone, and welcome to the 2021 Lloyd K. Garrison Lecture on Environmental Law. I should have said good afternoon. I'm Jason Zarneski, Associate Dean of Environmental Law Programs at the Elisabeth Haub School of Law at Pace University, and I'll serve as the MC and moderator of today's event. It's my sincere pleasure and privilege to welcome you all, as well as welcome our distinguished guest lecturer to this annual event. Now, I'd like to pass the virtual podium to the Dean of the Law School, Horace Anderson.
Thank you, Professor Zarneski, and good morning, afternoon, and evening to everyone joining us from across the country and around the world. I'm Horace Anderson, Dean of the Elisabeth Haub School of Law at Pace University, and it is my pleasure and privilege to welcome you to this distinguished lecture. Although we're not in person, there is a bit of a silver lining in that we are thrilled to have participants joining us today from all over the US and around the globe. We are also very proud to be able to highlight in today's lecture the crucially important topic of human rights in the context of environmental law. The Lloyd K. Garrison Lecture on Environmental Law was established in memory of Lloyd K. Garrison in 1995, 4 years after his death. More than half a century ago, Lloyd Garrison and his associate, Albert K. Butzel of Paul Weiss, Rifkin, Wharton, and Garrison, won a landmark decision to preserve Storm King Mountain on the Hudson River. This victory for the Scenic Hudson Preservation Conference did more than just safeguard an area of unique beauty and major historical importance. It also inaugurated what today we recognize as the field of environmental law. Standing in court to protect nature, citizen suit legislation, the environmental impact statement process, and the balancing of economics with the preservation of scenic beauty and historic resources. These are all rooted in the 1965 Second Circuit decision in Scenic Hudson Preservation Conference, the Federal Power Commission. The Lloyd K. Garrison Lecture celebrates the vision, public spirit, and life of this attorney whose legal acumen led citizens in their successful advocacy of environmental quality at Storm King. Through this lecture and the many other activities of our top-ranked environmental law program, Haub Law demonstrates its commitment to encouraging and promoting sustainable and responsible business practices, and recognizes the interconnection of human rights and the environmental imperatives that we face today. Now I'd like to introduce Smita Narula, Haub Distinguished Professor of International Law, who will say a few words about our distinguished Garrison lecturer, Professor Erika George. Professor Narula.
Thank you so much, Dean Anderson, and thank you, Professor Zarneski. Good morning, good afternoon, and good evening, everyone. It is my great honor and pleasure to introduce Professor Erika George. Professor George is the director of the Tanner Humanities Center and the Samuel D. Thurman Professor of Law at the S.J. Quinney College of Law at the University of Utah. She earned her bachelor's degree with honors from the University of Chicago and her JD from Harvard Law School, where she was also articles editor of the Harvard Civil Rights, Civil Liberties Law Review. Professor George also holds a master's degree in international relations from the University of Chicago. Prior to joining the S.J. Quinney College of Law, she served as a law clerk for Judge William T. Hart on the U.S. District Court for the Northern District of Illinois, as a litigation associate for the law firms of Jenner and Block in Chicago and Couder Brothers in New York City, and also as a fellow and consultant to Human Rights Watch. Her research, as you will hear about today, focuses on human rights and international law. So those are some of the really impressive things that you will learn about Professor George when you read her very impressive bio. But I have the great honor and privilege today of being able to share some things with you that you may not find in her bio. And the pleasure comes from being someone who has been fortunate to call Professor George a friend for the past 27 years. And as her friend and admirer, I get to share some of these things with you. To begin, Professor George is a nature lover. So much of the things that she posts on her Facebook, for example, show her engaged in nature. She is also an outdoor enthusiast, an incredible skier and a yoga instructor as well. And she is a world traveler. Here she is in a photo from Australia some years back. Professor George is also an incredibly committed activist, both locally and globally. Here she is at a protest for gun reform at the Utah Capitol. And then in this next photo shows her at a rally in front of the United Nations in New York City in support of Dalit rights and of a movement to dismantle India's caste system. Professor George is also a committed and celebrated member of her community, a community that she regularly and thoughtfully brings together in conversation in her role as director of the Tanner Humanities Center. In 2020, Living Color Utah honored Professor George as one of 20 individuals who have made it their mission to foster diversity and inclusion in the state of Utah. And what's more, she's been muralized. I don't know how many people can say that, but commissioned by Zion's Bank in 2020, this 5,000 square foot public art piece celebrates the impact of Utah women, past and present, in commemoration of the centennial anniversary of the 19th Amendment, which guaranteed women the right to vote. It's hard to see Professor George here, but she's in the top left quadrant. And if we do a bit of a close-up, you'll actually see that there she is circled in this close-up photo in the next slide. So Professor George is also an incredible person to attend conferences with. Our friendship began as law students in 1994 when we began preparing for and ultimately attending with other classmates the landmark 1995 UN Women's Conference in Beijing. We have since advocated for human rights in the halls of the Human Rights Council in Geneva, at the 2001 World Conference Against Racism in Durban, South Africa, among many other locations. And more recently, I've had the privilege of hearing her present at the American Association of Law Schools annual event, at the National People of Color Scholarship Conference, and at myriad other venues where she consistently elevates the caliber of the conversation and seamlessly weaves in and uplifts the contributions of others, even as she is presenting her own work. Professor George is also a dedicated teacher and a thoughtful and generous scholar. She is celebrated by her students and deeply committed to teaching as a craft, no matter the political divisions in the room. In her lecture today, Professor George will discuss the ways in which investors and advocates can leverage corporate and securities law to promote climate action and accountability for human rights abuses. The lecture draws on Professor George's terrific new book, just recently published by the Oxford University Press, entitled Incorporating Rights, Strategies to Advance Corporate Accountability. The book itself is based on nearly a decade of ethnographic research, participant observation, and interviews with activists, business executives, investors, and policymakers to provide insights into how public pressure can promote respect for human rights. Having borne witness to the process of producing this magnificent book, I can honestly think of no one else who so thoughtfully and skillfully straddles both the human rights and corporate law fields and brings measured and effective insights to bear on some of the most intractable and critical issues of our time. Professor George, on behalf of Haub Law School, a very, very warm welcome to you. And I so look forward to hearing your insights today. Let me now turn back to Professor Czarneski.
Thank you, Professor Narula, for that beautiful personal introduction. That was, I think, a joy for both of you and a joy for us to see. Now, please join me in presenting the 2021 Lloyd K. Garrison Lecture Award to Professor Erika George. This medal, which you see on your screen now, displays a topographical depiction of Storm King Mountain, paying homage to the landmark case won by Lloyd K. Garrison, and which now serves as the logo of the Pace Haub Environmental Law Program. The award, now bearing Professor George's name on the back, will be mailed to her after this event. Feel free to wear it at your next commencement ceremony. I now invite our distinguished guests, Erika George, to deliver the 2021 Lloyd K. Garrison Lecture on the topic, Incorporating Human Rights, Corporate Responsibility, Equity, and Just Environments.
I am speechless. I'm not sure how I'm supposed to give a lecture after all of this, but I will. But first, I will thank you all very much, especially my dear friend and sister in the law for so many years, Professor Narula. Professor Czarneski, thank you very much for the award. Dean Horace Anderson, thank you. Chinti, thank you for your patience and persistence in organizing this. And Katie, I wish you well in your studies at an astounding program in environmental law. I am in Utah, which is the unceded ancestral homelands of the Paiute, Eastern Shoshone peoples, and we are using the technology of Zoom, which is located in San Jose, California, the traditional home of the Ohlone people. I think it's important to begin to acknowledge where we are because it speaks to where we've been. I am going to share a screen and start this conversation about ways to incorporate human rights, the role of corporations in being responsible for creating just environments and reducing inequity. I will proceed in three parts. I'll begin with the problem, the interrelated issues, the ways that corporate social responsibility, human rights, and environmental justice intersect and disconnect. I'll then turn to the priorities that have emerged from how we've started to identify these problems and address them, the commitments that governments have made and some businesses. And then I'll finally turn to possibilities, ways we might make progress using market mechanisms, specifically shareholder resolutions as regulation, and other ways that investors can use their input and influence and information gathering to make some significant differences and take stock of where that is. A problem. This is the problem that drew me to this field when I was a young law student and interested in working for Human Rights Watch. I'm showing you an image of the late Ken Saro-Wiwa, who was an Agoniagoni environmental activist and also a poet. So I'm going to share some words from his poem that really give voice to the problem we're dealing with, or that he tried to address, the cost of his life. Agoniagoni is the poem. Agoni is the land, Agoni is people. Agoni is the agony of trees, dying in ancestral farmlands, streams polluted, weeping faith into murky rivers. It is the poison air caught in the luckless lungs of dying children. Agoni is a dream of breaking the chain around the neck of a shell-shocked land. So Shell was one of the firms with a concession from the Nigerian government at the time, led by a military junta under Sani Abacha, General Sani Abacha, that was operating in the area, including investing in infrastructure, roads, and security forces that ravaged villages. There were oil spills, there was environmental degradation, making it so that traditional fishermen couldn't fish. Foodstuffs became more difficult to obtain. And these were his primary objections. He wanted to end the environmental degradation that impacted the enjoyment of human rights for his community. Human rights are enshrined in international instruments. The Universal Declaration of Human Rights guarantees to everyone everywhere, even in the Agoni land of the Niger Delta or the Mississippi Delta, New Orleans, Louisiana, the same rights to equal protection of the laws, to civil and political rights, to socioeconomic rights. And I would submit that there are no rights recognized that are not impacted by the business practices and policies of global capital. Years ago, I wrote about Adolf Burl and trying to bring his work into conversation with our current contemporary problems, which I think he foretold in his book from the 1930s. He became an advisor to FDR and one of the architects of the New Deal. He was a law professor, and with his colleague, Gardner Means, wrote the book then on the modern corporation and private property. And his principal observation was that there was a shocking concentration of power that was growing so much that eventually he imagined it would compete with the nation state. He acknowledged that he recognized that there was a separation increasingly between the owners of the corporation, no longer the mom and pop shops that are owned directly by the people operating the business, but there was a separation between ownership and control. And in that gap, there were questions about who corporations were responsible to. And there was an increasing power to exercise. So power without responsibility, he imagined, would be a problem. And he turned out to be right. I argue that his work has been misread often to support a shareholder primacy obligation. So corporations are in service of the owners that are no longer day-to-day managers of the company, but that's what a company is run for. It's run for profits, it's run for shareholder profits. And situating his contribution in the context of arguably corporate complicity in human rights violations, which people did argue after the Kensera-Wiwa case in Nigeria involving Shell. Work in early corporate law is often read to justify a management myopia that looks to only shareholder value, to the exclusion of other values like human rights, environmental protection. And for a long while, that was the going conventional wisdom, that the responsibility of business is to increase its profits. But there is new wisdom and other wisdom that I want to bring to this conversation. And in the global policy arena, it was introduced by the late Kofi Annan, who in the 1990s, in response to the 1970s Milton Friedman doctrines of free markets and open markets without responsibility beyond profits within the boundaries of law, Annan had the insight that the business community, the global business community, could be aligned with the shared values that brought about the creation of the United Nations, which was to ensure peace and security for everyone, everywhere. So he went about the business of setting priorities. I'll take you through just a few. In 1990, due in significant part to Kofi Annan's work, the UN put forward the UN Global Compact. This is a body of corporations that agree to adhere to principles that are consistent with the norms of international standards of human rights protection. So there are human rights standards, labor standards, environmental standards, and anti-corruption standards. And if we think back to the kinds of problem that Kensera-Wiwa and many others who've since followed him have had, they've involved forced labor in extractive operations or human rights violations that degrade the environment, and often in league with government corruption. Publish What You Pay is an initiative that's been really doing some wonderful work to expose and disclose the monies that governments receive when there are questions of environmental degradation or human rights violation or just general bad governance. So this was a move in the standard setting policy arena to at least set a baseline, to begin a conversation about where it is we need to be if we are going to have a global economy. We can't simply sacrifice everything to the economy. We have to do more. And more is what Kofi Annan asked of the late John Ruggie, who we recently lost. In 2006, there was a resolution creating a special representative to investigate transnational business enterprises and their impacts. That mandate holder was appointed by Kofi Annan, and it was John Ruggie. And after 6 years of multi-stakeholder engagement and process, he came up with a framework delineating the responsibilities of business, the responsibility of governments, and the access to remedy the communities should have where businesses are involved in human rights violations. And it made clear that corporations do have a responsibility to respect human rights. It is not enough to say that it is the responsibility of the government where your operations are to ensure that human rights are protected. There is a role that business can and must play, and at minimum, that's to identify where there are human rights risks, meaning risks not to the business, but risks to people's rights, actual people's rights, and where there are risks identified to address them, to do something to avoid adverse human rights impacts, and even to remedy aggrieved persons who've encountered the adverse and human rights impacts. The human rights lawyer in me wants to say violations, but the language of this text looks to impacts. And I think that's important because what it did was convert and translate business principles into human rights instruments, interconnecting them in ways that business enterprises could understand and should be able to comply with. There are two principles that are relevant for my talk today. One is the guiding principle 19, and it calls on businesses to conduct human rights impact assessments and to integrate the findings of human rights impacts into operations. That involves doing due diligence. And then another one that I think is key for investors and shareholders and consumers alike is guiding principle 21, which calls for businesses to be able to know and to show, to know through doing due diligence what their impacts are, and then to publicly report out on them through disclosure, so to show. And what this gets us is progress on prevention of human rights violations. I would like to share the exciting news of a new human right, or rather one that's newly been recognized, and connect this to the environmental concern. So the Paris Agreement does have human rights references, but much of human rights law was developed in a silo, separate and apart from much of international environmental law. Just this year, we're seeing more culmination of that coming together. There's reference to human rights in the 1970s Stockholm Declaration. The intervening years have seen little discussion of human rights, but in the Paris Agreement, we do see reference to respect for understanding that human rights are impacted by environmental degradation. The UN also appointed or created, just as John Ruggie's position was a UN special representative, the first UN special representative on human rights and the environment, John Knox, was appointed and used his mandate to really do a scoping survey of the ways in which environmental issues and human rights issues overlapped and intersected, and looked throughout the human treaty bodies for references and opportunities. His successor, Professor David Boyd, has overseen the successful statement of recognition that the UN Human Rights Council issued just last month, recognizing a right to a clean and healthy environment. The work that needs to be done is working through the substantive content of what that right will entail, and the procedures for making sure that it's realized. So I'd like now to turn to talk about sustainability speak and translating human rights, environmental issues, sustainable development goals into the language of business. because I think it is there where there's possibility to prevent the kinds of abuses that led to the execution of Ken Saro-Wiwa and 9 of his other Agoni colleagues. So the Sustainable Development Goals, which were launched in 2015, supersede or continue the Millennium Development Goals, which were in 2000. And the question may be asked, how is it going to be different by 2013, our international community and our changes to get to a place where we can achieve these Sustainable Development Goals? And I argue that it will be through, in significant part, responsible business action. So here's some possibilities. Where there are intersecting interests between investors and the stakeholders who are affected communities, where human rights are influenced or impacted negatively by business operations, there's possibility to influence change in significant ways. So I began by talking about Adolf Burl and his concerns about ownership, and Milton Friedman and his commitment to shareholder profit. The Securities and Exchange Commission is the organization in the US, the governmental body that protects investors in capital markets and ensures that our markets operate with integrity and that investors have the information that they need to participate in the market. It allows business to raise capital and to grow. It is the gatekeeper on what is available to investors. So there are 2 ways in which I think investors can leverage securities law, and we're seeing them do more of it. One is through participation. The other is through seeking information. So the Securities Act has a rule. The Securities and Exchange Act, particularly rule amendments to 14A8 have been instrumental in allowing investors to put forward shareholder proposals. So shareholder proposals allow investors that own a certain amount of shares in a company to put forward a proxy statement. This is also interchangeably used with the terms resolution or proposal, but basically it's a statement that an investor can put forward to ask a company to consider a policy change or a governance change or make additional disclosures. And shareholders typically submit these in the belief that they will benefit the company. So there are other forms of socially responsible investment that concern screening out shares of stocks of companies that an investor doesn't want to engage with. This is engagement. These are investors who want to hold the securities, and they treat proposals as an important engine of corporate democracy, allowing the shareholder to raise concerns with corporate management, to manage risk, and to create long-term value. So what 2 organizations that have been at the forefront of shareholder resolutions have done recently have engaged both environmental issues and human rights issues. The Interfaith Center on Corporate Responsibility is a coalition of more than 300 institutional investors collectively representing over $4 trillion in assets under management. These include pension funds, religious investors, foundations, asset managers, and other long-term institutional investors such as the California Retirement Pension Fund, New York State's Retirement Pension Fund, and they've been active in shareholders' proposals. The organization was founded, inspired by faith, committed to action, and they have over 50 years of experience in shareholder proposals, though the organization began with concerns over apartheid in South Africa, where investors were very interested in whether to divest, whether to remain investing and engaging, but they have a long-standing record of engaging on environmental, social, and governance issues, and they've brought valuable changes about over the years. As You Sow is a single nonprofit and one of the nation's largest practitioners of corporate engagement and shareholder advocacy. Again, not divesting for over 27 years. What As You Show has done is corporate engagement and advocacy around issues that they perceive will promote positive social change. So they use this mechanism of shareholder proposals to monitor corporate management, raise issues, and ultimately to guide corporate policies. This is the opportunity for investors to have input. And increasingly, investors are interested in more than just the Milton Friedman model of profits. These used to be perceived as smaller or niche or even fringe types of investors, but they are moving more mainstream, and they are moving in the direction of making change. So their shareholder proposals have already helped mitigate collective action problems because they can operate together to put forward proposals. In my extended work in the book, I reviewed over a decade of shareholder proposals referencing human rights across multiple industry sectors, and saw over time the increasing sophistication of these proposals, referencing international human rights law, referencing the specific facts of particular cases in particular countries where operations were going in ways inconsistent with respect for human rights. So although shareholder proposals are not generally binding on management, a majority vote always leads to adoption, and even a minority vote can promote meaningful change. BlackRock, the world's largest asset manager, recently reported that companies adopted 94% of these proposals that achieved majority support, and even when a proposal didn't receive majority support, even in those instances, the company responded by making some change at least 67% of the time. And that is really extraordinary. So it isn't the case that there is nothing to be done about changing corporate governance practices. I'm going to spend a bit of time talking about some recent proxy priorities from the last proxy season, put forward by As You Sow, that are particularly relevant to the nexus of environmental law, environmental justice, and human rights, and climate change. So in the past year, in 2020, As You Sow actions managed over $793 billion. They conducted 131 corporate engagement in the proxy season 2020. 49 of them were on energy and climate change. There were 8 on food, antibiotics, 7 on pesticides, 5 on water use, for a total of 18. And then there were ocean plastics. So this is where they're focusing their attention. Their outcomes were also relatively good. The Securities and Exchange Commission can decide whether or not to act on these proposals. They can remove proposals that are inappropriate or ill-advised or not well-timed. Only 6 proposals were declined by the SEC. 22 proposals went to a vote. The impact was 45 of the 103 were withdrawn. And withdrawn means that engagement was successful. Withdrawn because the company met the demand or agreed to work toward it, or agreed to sit down and have dialogue with the investors, something they've been less inclined to do with affected communities. Sit down, have a conversation. So successes last year, Chevron published a report assessing the public health risks of expanding petrochemical operations in areas prone to climate change. That got 46% of a vote of $50 billion in assets. And beyond the extractive companies themselves, they're looking at other environmental impacts. Walmart, As You Sow, put forward a plastics proposal. Plastic bags are estimated to be, Walmart is responsible for between 18 to 20 billion single-use plastic bags. This contributes to ocean plastics. As You Sow has asked for Walmart to put in place a timeline for targeted phase out, and also to do a risk assessment. On that, they received 17% of a vote for $49 billion under management, and they will reintroduce this resolution. So resolutions progress through getting a certain number of votes, and if it doesn't succeed, it can be introduced at a time subsequent. And that's how the investor advocates have been operating, raising issues that have been on the radar decades ago. These are not new, they've been brought forward before. I'd like to say a word about what happens when a shareholder resolution does not win, doesn't get 90% of the vote, or gets less than, say, 30% of the vote. Even in those instances, these organizations have secured agreements. Most recently, the proxies have shifted some to looking not just at the extractive companies, but also the businesses, the banks that finance those companies. And they've put forward proposals before shareholders of Bank of America, of Goldman Sachs, of Morgan Stanley. And they're continuing conversations. Bank of America agreed with the As You Sow proposal to enhance climate risk reporting and to put in place a task force on climate-related financial disclosures and to begin to measure greenhouse gas emissions. Goldman Sachs has also agreed to evaluate its methodologies for the ways in which it financed emissions towards aligning it with Paris Agreement standards. And Morgan Stanley has committed to climate disclosure financed emissions and to test their portfolios, to test across portfolios for the impacts that they are likely to be financing for. This is significant. And Citibank conversations also continue. So these are the investor interests of the last proxy season, and you see they're expanding. A large portion of them are about climate change, corporate political activity, as there's been findings that politicians who are receiving funds from extractive and energy industry companies tend not to vote in favor of climate protective legislation. So that is significant. Workplace diversity, which speaks to issues of equity and bringing in different voices and vantage points into these workplaces, is also increasing. Human rights remain relatively low at 11%, but I think we'll see that increasing. And arguably, all of these issues are interconnected, interrelated, and I would submit indivisible. Andrew Bahar is the CEO of As You Sow, and I had the pleasure of sitting down with him for several interviews over the years. And he's really thinking we have reached a turning point. The devastation of COVID-19 really surfaced for industry their vulnerabilities as the most vulnerable, who were the essential workers being treated as expendable, made it difficult for their businesses to continue business as usual. So I think we are poised for a significant shift. And I agree with Bahar that investors also sense this momentum. Okay. So their interests are increasingly centered around environmental and social issues. They also are having impact. This is showing you the rate at which engagements are having outcomes that result in votes, that result in commitments from companies, and things that are withdrawn, which also often have resulted in some change on the behalf of the business and behavior. And then there are different types of climate change proposals. Essentially, most of them are still concerned with carbon asset risk. So framing environmental risks as financial risks seems to be helping the general move towards more action. And then on long-term trends, we are seeing more types of investors, more diverse types of investors get involved. If you'll notice that last column of 2021, foundations and schools are looking to where they're investing. Harvard, much celebrated recently, divested from fossil fuels. Others are looking at how to engage and make change. So pension funds, unions, beyond the special interests, there's more attention to this issue. And there are some really significant wins. Recently, Exxon experienced a shock when they lost 2 board seats to an upstart hedge fund, Engine Number One. In years previous, they lost a proposal to the New York State Pension Fund requiring reporting on climate change and greenhouse gas emissions. But the significance of changing the corporate governance, what Engine One did was put forward a slate of candidates that were dissident candidates to the corporate board that many are hopeful will be more mindful of transitioning to cleaner energy. So this capped off strategic concerns with Exxon's direction. And not insignificantly, Exxon has also been implicated in human rights abuses in Indonesia, over pipelines, and elsewhere. So while the relatively smaller investors or the traditionally socially responsible investors who've put forward these proposals for decades have been doing the work, they're now joined by evolving thinking from Main Street, Wall Street. So this is an image of Larry Fink, who has been at the forefront recently of conversations about reimagining corporate purpose. In 2018, he made a big splash with a letter to his investors. BlackRock is the largest investment fund in terms of assets under management. And he invited the investment community to really reconsider where their priorities were, how they were assessing risks. And this letter was signed on to by some of the largest publicly traded companies of the world. So the Business Roundtable Purpose of a Corporation letter had 181 signatories. These are all CEOs now making a stated commitment that they will be working in service of all stakeholders, not just their shareholders, identifying stakeholders as consumers, employees, suppliers, and communities. Signatories, Jeff Bezos is an Amazon, Tim Cook and Apple, BlackRock itself, DuPont, Chevron, Citigroup, Coca-Cola, Goldman Sachs, all companies that have faced shareholder proposals asking for information about protecting human rights in the supply chain, asking about environmental impacts. So I don't think it's a coincidence that the growing consciousness that's changing has been maybe the fruition of seeds planted by early activists interested in human rights. So I've told you a lot about successful proposals. Perhaps a victim of their own success under the Trump administration, the shareholder proposal rules were modernized to more than 10 times increase the amount of shares owned before putting forward a proposal, making it more difficult to aggregate shares, to be able to come up with enough to put forward a proposal or a vote, basically making it nearly impossible for the average Main Street investor, as distinct from a Wall Street investor, to have the privilege of a voice in putting forward proposals. I am delighted to announce that just on November 4th, so As You Sow and ICCR sued the Securities and Exchange Commission for the rule, seeking to have it overturned. And in the new SEC administration, the Trump era rules were rescinded on the 3rd of November. The policy is now to make an easier path for these kinds of proposals, because it's been the ESG proposals that have identified what ultimately become financial risks, making for a more healthy business enterprise, a marketplace that's has more integrity. So what would have been influence curtailed, there may be efforts to restart or start back stronger with this. I think it's also significant to note that the larger investors would have been fine, the Larry Finks of the world, fine under a rule change, but these are rules to watch, and I think ones that conventional human rights activists have not, but there's reason for optimism about common cause. In addition to input, information is increasingly becoming important. There's a corporate human rights benchmark put forward by Aviva Investors that is looking to rank and assess corporate human rights performance. There is a task force for climate change related financial disclosures that's doing work. We're seeing agencies like Fitch, Morningstar, and other credit rating agencies looking for ways to make ESG, environmental social governance ratings, more significant. So in addition to influence, when investors ask for information, they generally get it. And if they ask for information that is relevant to how communities are being affected, there's potential for those communities to benefit if there's positive change. There's been positive change at the SEC. The Secretary, Alison Her, has made a statement well, she made a wonderful statement back in March 2021, requesting public comment for new climate disclosure rules, making what is currently a voluntary space potentially mandatory. So corporate sustainability reports will speak to recycling or other sustainability features, but sustainability speak isn't connected as closely to the substance of human rights respect requirements as, frankly, I would like to see. There's an opportunity here. This is also the leader who put forward the first ever climate and ESG task force, and that will be within the Division of Enforcement to proactively detect companies that are engaged in climate and ESG misconduct when reporting. And she's also agreed to become engaged with international sustainability standard setting. So if we set these standards, if we measure risks, there can be meaningful difference because those that are reporting are also those business entities that have connections to impacts for good or ill in the communities that are host to their operations. Another encouraging sign has been President Joe Biden's executive order on climate-related financial risk. This order, which was released on May 20th, 2021, giving the government 120 days to deliver a comprehensive plan across the government-wide, provides that it is the policy of his administration to advance consistent, clear, intelligible, comparable, and accurate disclosure of climate-related financial risks, including both physical and transition risks, acting to mitigate that risk and its drivers, while also accounting for and addressing the disparate impacts on disadvantaged communities of color. This is an encouraging development because it acknowledges environmental justice is a key piece of any response that is going to be just climate action. So trends. The trend is toward more information. That encourages me. The trend is for more institutional investors that have power and influence to seek change. That is also encouraging. But to be sure, there remain challenges. There is the objection of administrative institutional efficiency. Should the SEC be deciding or weighing in on issues of the environment and human rights, to which I say yes, but interagency cooperation will be essential. The other objection that commonly is raised is cost. What is it going to cost to transition, to do all this reporting and to make the changes to be able to report favorably? I would suggest that we count the costs on the other side, the things that we have not counted in the past. That needs to be and has to be incorporated not only in our market calculations, but really the compass of our morality as we move forward in this decisive decade of dealing with climate change. I am still processing the outcomes of the COP26, but one thing that did strike me, in part because it was tweeted by the UN Special Representative on the right to a clean and healthy environment, David Boyd, human rights are not referenced at all in the COP document unless that has changed. So my question to you, to us as environmentalists, is where are human rights? Where are the rights? The UN guiding principles are entering their next decade. It was 10 years ago that they were unanimously adopted by the UN Human Rights Council. The responsibility to respect, the duty to protect, and access to remedy for aggrieved communities. Communities continue to be aggrieved. I don't want to leave you with the sense that hedge fund activists are going to save us. It's more complicated than that. I'm going to close out with two stories about just environments. So Engine One has been much celebrated for taking on big bad Exxon. It turns out that they are also invested in enterprises that have adverse impacts on the environment and arguably civil rights. I'm sharing an image of what will be an expanded set of grain silos in Greenfield, Louisiana. funded in some part by Engine 1. This is in an area of land owned by formerly enslaved individuals, Black, who have been on the land for many years. And I'm also sharing a photo of Lawrence Alexis, who's a resident, who's concerned about the environmental impacts, the air quality that will be diminished were this project to be expanded. So it's complicated. Doing something arguably good in one place, if we take seriously human rights impacts and corporate due diligence, we should be looking at all the places we are doing business and the ways in which we are doing business. And that's the argument that's being put forward by As You Sow and our colleagues at the ICCR. I have recently had the pleasure of joining the board of Earth Justice. Earth Justice has a relatively new Healthy Communities project that is focused on environmental justice, on these trade-offs and costs and consequences and conversations on impacts for communities, and ensuring that our representation is not just the earth. Yes, the earth does need a good lawyer, but the people who are defending the planet also need protection. So decades apart, oceans apart, Berta was assassinated much like Kinsarawiwa, only hers was an execution by assassins at her home in the middle of the night. There was some semblance of a show trial in Kin's case. But here, similar work, doing the work of environmental protection, also an Indigenous individual. She co-founded the National Council of Popular and Indigenous Organizations in Honduras. She had been working to stop a dam that was going to go across her river, a river that her community relied on for food, for sustenance, for sacred ritual. And it cost her her life. Her killers have been prosecuted just this year. And one of them, the architect, the mastermind of the assassination, was a man who worked for the business enterprise that was putting forward this project. After her execution or assassination, the project lost funding, lost funders. It won't go forward. It cost her her life. And these are conversations that we could have had, that financiers, I think, should have had, identifying human rights impacts, addressing them, assessing them, and ensuring that communities have access to remedy. Investors have an important role to play in deciding whether or not projects go forward. Things that we might do. I want to close with some opportunities. I think this is a good story overall, and we're going the right direction. But as we go forward, governments can do a lot to promote policies on transparency. They can ensure that there's coherence between the human rights responsibilities of investors. They can provide guidance to investors and businesses and investors, particularly on fiduciary duties. If you are investing as an institution for others, you have a financial obligation to them. And violating human rights has got to be a bad bet. And then if you are an investor, assessing the human rights risks that are present in your portfolio, and being an active manager of the assets that you do have. You could file and support shareholder proposals that are consistent with the values of respecting human rights and protecting the environment. And you could publicly demand disclosure. How are human rights risks being managed? Making that mandatory, moving beyond voluntary could make a big difference. So there's one vision of what freedom is and free markets. I'd like to close with another way of thinking about freedom, and it's the freedom to be living a life that's free, that enhances the lives of others. So while you may not have a multi-million-dollar, billion-dollar, zillion-dollar equity fund that you manage, there may be ways that you can manage the ways that you consume and the ways you ask questions the corporations that you consume from in a way that is respective of others, that respects their freedom and ability to be and to live. We live at an incredible time of change and transition, and we have the power to be a part of that change and to reimagine the purpose of powerful entities and actors in our world, principal among them, the business enterprise. So thank you for having me, and I look forward to our conversation.
Thank you so much, Professor George, for that lecture. At this time, we will begin the question and answer session between our attendees and our distinguished lecturer. To our attendees, if you haven't done so, we invite you to submit your questions to Professor George via the link and code provided in the chat. While we won't have time to get to every question, we're going to do our best to provide you with the opportunity to ask as many questions as time allows. So Professor George, our first question is from Professor Nicholas Robinson, my colleague at the Elisabeth Haub School of Law. He says, some companies have metrics measuring attaining sustainability beyond what is legally required. How can audits cover SDG metrics by 2030?
Okay. I would turn back to making it mandatory and standardizing them. Right now, it's sort of a choose your own adventure sustainability reporting system. There's SASB, there's the Global Reporting Initiative, GRI. I discuss some of these in my larger work, but I really do think there'll need to be coordinated interagency leadership within the United States, and beyond that, some broader coordination. There are some exchanges that do make mandatory non-financial reporting, but I think our real challenges are standardizing the substance of what needs to be reported in a way that there are various proposals. One would be to make it industry sector specific, but I do think that we need to pull in the same direction with enough flexibility to account for the different types of business enterprises. But if our baseline is you are able to trade on a capital market, I'm talking about public companies. There's some private companies that are doing spectacular work that hasn't been required and are reporting more than is necessary. My hope is that those businesses become leaders, that the B Corp movement really becomes something that others model and fashion themselves after. But for the large transnational, multinational, I think there needs to be clear, mandatory, standardized reporting. And which one will win out, I can't say, but I do imagine that the GRIs and SASBs of the world are talking to the Securities and Exchange Commissions and equivalents around the world to make sure that we get the information that we need to make a difference.
Thank you for that. Our next question is from the president of the Pace Environmental Law Society, Gabriela Mikkel. She writes, institutional investors act on value, not values or morals. So what can we do as law students and young lawyers to continue to build the business case for human and environmental rights?
Great. You probably are, I'm a Gen Xer, there's like 3 of us, so we don't quite move markets, but there's going to be an intergenerational wealth transfer coming. Investors vote value, but value shifts with what our values are, right? It becomes more and more expensive and costly to be engaged in human rights violations, whether you're complicit, connected, or contributing to them. When I interviewed business enterprises, they were deeply concerned about risk to business related to risk to human rights, right? You do not want to be that business on the front of the Wall Street Journal. I think that if values shift in ways that translate to value, meaning costly to be engaged in, that could move things tremendously. And I think, guessing your generation, I actually don't know it, but the large demographic population bubble that is coming up can make demands, and you can make a difference. I think we even see this with the labor shortage, right? the thing to remember is that you are not powerless. There are different ways of doing business that some businesses are doing. I'm thinking of Patagonia. I'm coming to you from Utah. Patagonia used to come to Utah until it decided it wasn't and took its whole outdoor retailer conference that was with them when they left and went to Colorado because the government here refuses to protect public lands. There's more to the story than that, but there are ways that business leadership can shape and influence change. Now, how consistent will BlackRock and others be with what they state? I don't know, but I think the business case is shifting with the culture, the demographics, and frankly, the market necessity to be able to engage a new kind of consumer and a new kind of investor.
Thanks for that. Always good to hear an answer from a fellow Gen Xer. You've met now the audience met 2 of the 3 Gen Xers left. This is sort of a consolidated question. Several of the anonymous attendees have referenced the mandatory human rights and environmental due diligence directive that's currently emerging in the European Union, as well as related national laws that have passed in France and Norway, requiring companies to regulate themselves and ensure no violations in human rights. One of our LLM students at Haub Law, Paco Miguel, also mentioned the EU Sustainable Finance Disclosure Regulation that requires financial players to disclose their sustainability impacts. Yep. So the question is, do you think these kinds of actions will prove effective in the European Union?
Absolutely. And I was remiss in not mentioning the rest of the world. Thank you, Anonymous Mini and LLM students, for raising it. Europe is leading on this. I mean, it blows my mind. France has the duty of vigilance law, where they're requiring reporting. They are not treating non-financial environmental and social issues as non-financial. I think when those regulations come online, because many businesses are going to have to report to that standard anyway, they may do it here as well. I mean, if to the extent that something is cost, they're going to have to incur it. I think there's a lot of learning that can take place. Germany has something interesting happening now as well. Also Australia. And there's the King Code in South Africa that is making securities that are traded there also have to have social reporting. What would be wonderful is if somebody could do a typology of the types of things across these different instruments that are being sought and connect that to how that's going to improve conditions for people on the ground. I think that is a bit of a missing link. But yes, tremendous progress in Europe. They are also doing really well on trying to get a handle on regulating technology and with human rights impacts that are adverse. So I don't know if that's a response other than I wholly agree. I guess it's not a mystery, but the unfortunate thing is I don't see us going that way that fast, but I'm very encouraged by the SEC recently putting forth the desire to get comments and to be a part of standard setting. I just wouldn't want those standards to be watered down if other elements are introduced, but I think Europe is well on its way to finding a sustainable way to do new kinds of business.
Thank you. So we have time for one final question. And this one hits a little bit closer to home in New York. So New York State's constitution was recently amended to protect a right to clean air, clean water, and a healthy environment. And so the question is, how do you think this might impact corporate conduct in New York State?
I think it will be effective, and I'm trying to think, I'm just being optimistic. There is nothing more sobering than a lawsuit. And if this becomes justiciable and claims are tested, this could be something that matters. Now, I will say most of my colleagues in the human rights international community are very interested in and engaged around having an international treaty to regulate business and human rights. The realist in me knows it's not going to happen because the US has killed it multiple times over, and it's just not going to move forward. Or it'll move forward without the US, which, yeah. But if this were done disaggregated at state level, like what if Delaware where there's a lot of corporations incorporated, started passing really progressive environmental human rights kinds of statutes. I am very excited about New York. I'm very excited about regional and state engagement and legislation. So yeah, law matters. Business pay attention to law. Was a law, and we'll see what the new administration does. I'll wrap this up. There was a conflict minerals disclosure reporting law that happened during the Obama administration. I interviewed businesses, they had to comply. There were people being sent to the Democratic Republic of Congo to figure out where their smelters were, where they were sourcing from. Yes, it's a motivator, and a strong one, because accountability. Yes.
Well, thank you so much. This brings us to the end of our 2021 Garrison Lecture. I want to thank Professor George for providing us with her incredible insight on this very timely topic, and our attentive audience from all around the world who joined us for this event. We hope everyone enjoyed today's lecture. I do want to give a special thank you to our Environmental Law Fellow, Katie Horner, our Assistant Dean for External Affairs, Rachel Silva, our Tech Guru, Greg Likens, and Ashinthi Vinthanage, the Associate Director of Environmental Law Programs, for all their hard work behind the scenes in pulling this event together. So thank you, everyone. Please take care of your intellectual, spiritual, emotional, and physical well-being in these challenging times. And we look forward to seeing you again virtually or in person at the Elisabeth Haub School of Law at Pace University. Thank you all.
Thank you for coming. As a reminder, today's lecture is being recorded. So if you were unable to watch the present lecture, you can watch it. It will be uploaded to the Pace Law School website for future viewing. Finally, we encourage you to visit our Twitter page and share your comments about the event. Thank you, and enjoy the rest of your day.